Looks like the parties are ready. Ms. Wilson, you may begin.
May it please the court. Counsel. In this appeal from his conviction for murder in the first degree, defendant appellant Christopher Thompson does not dispute that he killed his mother. He turned himself in to police and gave full admissions. His dispute both at trial and on appeal is the admission of irrelevant hearsay evidence under Rule 5.8033. The rulings in both the District Court and Court of Appeals rested on State versus Newell. Newell did indeed involve a 5.8033 claim, but it also involved a 5.404B claim, prior bad acts. Courts have now conflated these two standards, citing Newell's 404B nature of the relationship relevance standard to justify admission of statements under 5.8033. We are asking...
Deep into the 5.404, help me understand my review of the file. Looks like that error may not be preserved.
There was no Rule 5.404B argument presented to the District Court.
The court ruled instead on 803?
That is correct. And the parties in this appeal agree that there were no prior bad acts evidence presented in the District Court to make that rule at issue here. But what we are asking this court to do is to clarify the requirement of relevance for Rule 5.8033 and specifically find that there is relevance is lacking here. State versus Newell certainly does allow for admission of a victim's statements under 8033 as long as they are relevant to a legitimate issue in dispute.
Are you saying that we don't have to overrule Newell to rule your way?
In Newell, the victim's state of mind or emotional condition was relevant because the defendant was claiming he had a loving and amicable relationship with the victim. Her statements directly rebutted his characterization. There is no such characterization like that here. The defendant admitted he killed his mother.
Victim's fear of the defendant is only relevant if the defendant claims that they had a good relationship?
Necessarily. There may be other grounds for relevance, but
Alice be one of them?
potentially, but the record needs to be made that shows how that is relevant to malice in that specific case.
Well, I'm not so sure that everything in Newell is correct. I'll just throw that out there. It does seem to me basically that there's a problem in the case, and the problem is this. You're allowed to have evidence that the victim told people she was afraid of the defendant to show the victim's state of mind if the victim's state of mind is relevant. But you're not allowed to have the statements that the victim was afraid of the defendant to suggest that there were things that the defendant did to the victim because then that becomes a hearsay problem. And that's my problem in the case.
The rule is fairly clear that the emotional condition of the declarant can be admitted, but statements of memory and belief cannot. And McCormick speaks to this, exactly the situation you discuss, where there can be prejudice from statements of fear standing alone because it allows the jury to speculate. The defendant, why did she have the fear? The defendant must have done something. What did the defendant do? But then there's also the potential prejudice from allowing these extraneous statements attached to the statement of fear, which McCormick recognizes rarely come in pristinely. And that prejudice or harm is that the jury then considers those allegations.
Hearsay, right? I mean, that about the posting of the video or cutting up the credit cards and things like that. Those are not statements of a mental condition. Those are statements of things that that happened being offered to show that those things actually did happen, which is hearsay, right?
So we have the problem. Now, below and here, we have argued that these statements by the declarant should be excluded in their entirety. We're not asking to parse them. That wasn't requested below, but they should be excluded in their entirety because they are not relevant to the defendant's state of mind. And here I think it is helpful to have a discussion of the case law as it is sort of developed. Now, interestingly enough, you know, the state, the district court, the Court of Appeals all rested their decision on Newell and referred to the 404B language about the conduct of the defendant in a relationship, going to the nature of the relationship and therefore motive, intent, malice. But that's not the standard for 58033. The district court itself did not ever do an analysis of how is this specifically relevant to the defendant's state of mind in this case. It simply referred to that language in Newell. The Court of Appeals did a little bit better. They referred to cases such as Kellogg and O'Connell for the proposition that it was established law that quarrels and physical acts within a relationship is relevant to a defendant's quo animo or motive. But look at Kellogg, look at O'Connell, look at the cases cited within those cases. They are all conduct cases where the defendant's conduct was used to establish inferences regarding his intent, malice, and motive. Here, it is just blanket statements of fear by the declarant.
Blankets of statements of fear, they're pretty significant. And when we're talking about relevance, same day that she's actually murdered, and he admits he murders her, that the communications that were stated by her, and putting aside the actions, the words that were mom's, which she, if she had been given an opportunity to testify, I have a feeling she would have said, I am tired of being scared. He's a drunk. I called the cops and they said to contact you. I need your help. I'm done. That Facebook video, she whispered how fearful she was. It's not just words. I mean, if she could have testified, so let's talk relevance. Wouldn't those be relevant?
I want to distinguish between what goes to the jury and what the court can consider on relevance and admissibility. So the jury, as Justice Mansfield pointed out, really shouldn't be hearing any of this as far as specific acts, specific factual assertions. But when it comes to the district court determining relevance and admissibility, they get to consider things like spontaneity and contemporaneousness and sincerity. They all go to reliability. And in this case, what the defense argued below is that really, if you want to let these things in, they need to somehow be tied to conduct of the defendant. Because what we do have here is generalized statements of fear, but we don't know what precipitated those. And just generalized statements of fear, people can be afraid of a lot of things. It needs to be relevant to the defendant's state of mind, and they're not. But let's talk about the different pieces of evidence.
I'm not with you on the generalized, that it doesn't, I think that the facts as testified to, Ms. Moylan testified, the friend, of an incident 3 months before the murder and then 1 month before the murder. And it sets the stage. It's not just general. It has to do with, she told him to move out. And there are cases, aren't there, out there that even a mom saying, I'm going to cut you off financially, isn't that akin to somebody trying to break up with somebody?
It's definitely akin to a plan, as in Newell. So, yes. So there is potential here that these statements can fall under that hearsay exception, but they still have to be relevant to the defendant's state of mind. It's not simply that they qualify under hearsay, they now get admitted.
I think Newell makes it, to some extent, more complicated than it really is. Either either you can bring in all kinds of, everything that, all these statements, if you had firsthand evidence that these things actually occurred, they'd all be relevant. And I don't think your client would have a leg to stand on as far as arguing that they were inadmissible. But they only come in through the out-of-court words of the victim. And that does present a hearsay problem. And the only part of them that might be a hearsay exception are the statements of fear. And those are only relevant to the extent they suggest that things happened of which there's no direct evidence other than, again, hearsay. So it seems to me it's a problem. Am I missing something? I mean,
For admission. They have to have some probity to the defendant's intent. And it's one thing to say the defendant's conduct is probative of his intent because he's in charge of his conduct. We're allowed to assume he intends the natural consequences of his acts. With somebody else's statement, you don't have that linkage. And that's really what defense was arguing below.
harmless error, because this is a horrific crime, and there's a lot of evidence of premeditation in the record.
I would dispute that there is a lot of evidence of premeditation. The defendant's theory, his version at trial, was that he was full of rage. They did not have a good relationship. Nobody is disputing that. And he testified, or well, he told the officers that he sort of blacked out. He was essentially on automatic pilot when it happened. Now, the jury doesn't have to determine just whether he killed his mother. The jury has to determine what his intent was, whether he had malice aforethought. So the defense provided the jury the dispute of, is this murder in the second degree? Is this voluntary manslaughter?
Wilson, because you walked right into it with Newell. We have said that relationship between victims and their assailants is relevant. And then according to Newell, an essential element of first-degree murder is malice aforethought, blah, blah, blah. Prior relationships, including bad feelings, quarrels, and physical acts, is a circumstance that may be shown to prove the defendant's state of mind and motivation at the time of the crime. I don't understand how you can get around not overruling Newell to get what you want.
Newell distinguished between 404B prior bad acts evidence and 803.3 hearsay evidence. And everybody is using the prior bad acts language to apply it to 803.3 to get in this hearsay evidence. Again, it's one thing to say the defendant's conduct is probative of intent versus some generalized fear of the declarant.
If we're looking at this, the standard of review is abuse of discretion, right? Are you saying that it was an abuse of discretion to find any relevance between any of these statements that were admitted? I mean, it's at least arguable under the case law that it's relevant. And I certainly am not sure that you could say the district court judge was way out of bounds in concluding it was relevant, since we have a case right on point that says it is.
Rulings are generally ruled on for abuse of discretion, but hearsay questions are for errors at law. And if this court should determine that lower courts, this court here, Wilson is another case where they do it, has misapplied Newell's 404B analysis to 803.3, then this court can correct that error.
I think we say hearsay is reviewed for corrections of errors at law with respect to whether or not the exceptions are satisfied. As I read your brief, you're really just arguing relevance. I think you concede at page 28 that the hearsay exception is satisfied, and then you're just arguing about relevance. Is that wrong?
I believe my brief says statements of fear might be admissible, and to the extent they qualify as statements of fear, So I think we need to distinguish between statements of fear versus the extraneous information that comes with it. And perhaps it's more helpful to this court to consider those statements in conjunction with prejudice and harm.
Those actions, even if the court would say, okay, you still got a lot of statements and you got a lot of other evidence of what this guy said and what he did and that the circumstances surrounding. I mean, she was murdered on the 13th, I believe, and finally on the 18th he turned himself in. So we're allowed to look at how people behave, you know, in the circumstances. There's a lot of evidence. Really quick, what's your quick speech on harmless error?
It is still harmful because the jury has to determine intent and malice. It could use permissive inferences regarding dangerous weapon and nature of the injuries and look at that other evidence, but it doesn't have to use those inferences to find intent. And it shouldn't be this court's role to determine what a jury would have found if this evidence had been properly excluded. Thank you.
May it please the court, counsel. Good afternoon. In cases of domestic violence, and especially in cases of murder, a now dead declarant's out-of-court statements might be some of the most probative evidence of the defendant's intent at the time of the crime. The district court, considering this court's jurisprudence and the Court of Appeals' applications of it, did not err in admitting the evidence in question here. We're here today, as you pointed out, Justice McDonald, to talk about relevancy. Justice Mansfield, I appreciate your questions about 58033's subsequent things remembered conversation, but our question here is, did the district court abuse its discretion in admitting relevant evidence?
Let's cut to the chase. I think Ms. Wilson mentioned McCormick, and McCormick discusses this very scenario and talks about why it's problematic. So here's what he says. A recurring problem arises in connection with the admissibility of accusatory statements made before the act by the victims of homicide. If the statement is merely an expression of fear, I'm afraid of D, no hearsay problem is involved. However, this doesn't resolve the question of admissibility. The victim's emotional state must relate to some legitimate issue. The most likely inference the jurors may draw from the existence of fear, and often the only logical inference, is that some conduct of the defendant occurred and caused the fear. So what is the independent evidence what is the non-hearsay evidence that the defendant caused the specific fear that these out-of-court statements were supposedly in for?
A conclusion from reading this court's jurisprudence following Newell, including Richards in 2012 and 2016, is the fact that this state does not agree with Mr. McCormick's interpretation, and I would submit further.
Case, all right. There was independent evidence that it was not statements that were made. There was independent evidence of his abusive conduct toward the victim in that case,
No, that's all right. I think I'm not going to ask a question, I apologize. In Newell, this court found, and it refers to, in determining the relevance of the hearsay question, it referred the reader to go to the 5404B discussion because those two conversations will explain the relevance of the statement. And the court's observation was a sound one. When we're talking about domestic relationships, there is a two-way street, and we can infer from one party's feelings about the relationship something about the other party as well, especially in cases in which that party's intent is one of the critical issues to be resolved by the fact finder.
How is that not hearsay evidence unless you have the independent evidence out there? I mean, if
Subsequent fact that he killed her with a crowbar serve as independent evidence that he had engaged in conduct that caused her fear in the past. It seems a logical inference to me.
In fact, I would add that this record is not vacant of other references to quarreling, to disagreement.
isn't that bootstrapping? I mean, to take the crime and then use the crime to go backwards and introduce the fear. I grant you that there is language in Newell that supports the ruling in this case, and I question that language, and I'll be open about it. I think it was wrong, possibly.
In these cases, this sort of evidence, especially given the context in which these cases occur, supports the admission of this evidence. We shouldn't allow for sanitized versions of reality when in fact we have probative, relevant evidence admissible under a hearsay exception that might shed additional light on the circumstances in which the crime occurred.
I'm sorry, how does a statement that the victim fears the defendant shed light other than by itself, other than allowing the jury to infer that the victim did things to cause that fear, which then becomes a hearsay? It's just, it's the classic example we learn in evidence class in law school. You can use statements of a person's emotion or state of mind to prove their emotion or state of mind when that's relevant, but not to prove what they remembered or thought or what it was that.
We have a fundamental disagreement about the logical tether here, and I am submitting to this court that its prior announcement in Newell was correct, that there was a logical tether from a victim's subjective fear of a defendant to that defendant's intent then and subsequently. And to the extent that you feel that Newell needs to be revisiting, this simply is not the case to do it. This is a case in which, as your questions have already intuited, we have additional indicia of quarreling between the defendant and his mother prior to his death, additional evidence that they had been arguing, and the circumstances of the case certainly.
Evidence of that.
Evidence. I believe questions were posed to Lori Baker as well as Steve Courtney. Steve Courtney interviewed the defendant upon his arrival at the Polk County Jail, and he admitted to past quarreling. You have the defendant's own statements in the recording that he had shoved his mother in the past and that they had argued previously. And you also have, I'm sorry if I already mentioned this, but Lori Baker was familiar with the decedent and referenced the fact that the relationship was not always on good ground. Again, these are, to my mind, non-hearsay evidence in the record that even if you were inclined to revisit Newell, and I would ask that you not, it's just not the case to do it.
The evidence is being, they even use the word circumstance in Newell. It's circumstantial evidence, and we give that job to the jury. I want to move on to a different issue in the same case. And in particular, what I'd like to ask you is, how do we look at the passage of time? For example, the Facebook video was 3 months before she was murdered. The other conversation with that same witness was a month before. And then we have the probation officer who received an email the day of the murder. Can you talk about the lapse of time?
All of these incidents fall well within the outer bounds of relevancy. In Richards in 2012, the court was reviewing hearsay statements that occurred 9 months before the murder in question. I think certainly a hearsay statement the hours before the murder is sufficiently relevant to permit its admission here.
When we look at whether or not harmless error, if for some reason these, if the court would come to the position that it was error for the court to allow these, the admission of these statements, tell me where we'd go from there.
Well, I would suggest that this is one of the better records I've seen for harmless error. Just to begin with the circumstances of the crime itself, and then I'll backtrack a bit if you'll permit me. We have an individual who has admitted that in the middle of a vocal argument with his mother that he decided that he wanted the arguments to end, that he walked across his house into a stairway to procure a crowbar, a deadly weapon under our code, and then with the intent to end the argument, walked back to his mother and struck her once without saying a single word as she raised her arms. I believe there were defensive injuries to support that. And then after she had been felled, struck her again and again and again and again, 7 times by his count, but he wasn't sure. And the medical evidence, to be frank, was unable to determine, in fact, how many blows had been struck. And that's not all. At that point, he dragged his mother into a room after throwing a towel over her. And then as he cleaned the murder weapon, her cat had the poor misfortune to cross his path, and still angry at his mother and still quite upset, he slayed the cat, destroyed her phone, and then stayed in the house for 5 days, lying about her state, saying that they had been arguing and that she was on a drinking binge. There is no question that this was first-degree murder. It is not harmful for this evidence that was important to determine at the moment that he struck his mother what his intent actually was based on the circumstances of their relationship.
And that's a compelling recitation, Mr. Howe, but I mean, there are cases we see where the jury comes back with second-degree murder and we're surprised. I mean, how would we know that might not have happened in this case without these statements.
I mean, the nature of our harmless error review does look exactly at the evidence presented at trial to determine whether or not the jury would have or would have not reached the same outcome. I can admit, in my own practice, I've seen cases where I, too, am astonished that a second-degree murder is the verdict. But that doesn't warrant the intervention that you're proposing, Justice.
And you got a little bit of time left. I would like for you to address the issue where it appears to me that Ms. Wilson is attempting to distance herself from another case by saying they're not saying it was a loving relationship. That is in her brief as well.
I just don't find that a persuasive distinction. I mean, the core inquiry of this trial was, did he possess malice aforethought, and premeditated intent to kill at the moment he approached his mother with a crowbar?
Point, Newell, the defendant claimed it was a loving relationship, and Richard, I think the same thing. What's your best case where that wasn't an issue, where the evidence wasn't relevant to rebut a claim, oh, but I didn't hurt this person because of our good relationship?
I think, forgive me if I'm misremembering, it's either Wilson or Ingram from our Court of Appeals. I think it involved sexual abuse of a minor, and
I think we said that the victim's state of mind was relevant to show whether or not she consented to the sex act.
we are litigating whether or not a necessary element has been proven by the state, premeditation of intent to kill.
Is the victim's state of mind relevant to the defendant's intent?
I don't mean to be crossing ships in the night, but the link here is that a relationship in a domestic situation where two people are living together, cohabitating, and it might not be a particularly good relationship, we do have the necessary logical link that makes that person's feelings about the relationship shed light on the defendant's state of mind and his view of the relationship as well. It's certainly minimally relevant.
Case that you mentioned besides Ingram.
That was another murder case, but bear with me because that one may too have dealt with someone maintaining that they had a loving relationship. But I think that distinction only goes so far, which is to say that it has to be intent that we're talking about here. That's when this evidence is most relevant. And if you'll forgive me for being, this court's recent pronouncement in Crawford makes the need for this evidence all the greater. Because if we're going to review sufficiency on the far side without any objection from the parties, we need the evidence to prove beyond a reasonable doubt to this court's satisfaction that the defendant has the necessary mental state at the time he commits his crime. So if it satisfies the minimal relevancy standard and it satisfies a hearsay exception, it should be admitted. For the foregoing reasons and because none of this evidence prejudiced the defendant's substantial rights, the state would ask that this court affirm. Thank you.
Wilson.
May it please the court. I wanted to address this idea that the subsequent killing somehow allows these previous statements to come in. Finding incriminating evidence from an illegal search does not render the search legal. And the later killing of a declarant doesn't ipso facto render the declarant's statements admissible.
That in the context of domestic violence, and in this situation, it's domestic violence. I don't care if they're mom and son, they're living together. Domestic violence, there are cases, there are situations, that's different. That's not a fair comparison. Do it in the context of domestic violence.
Domestic violence cases, what I'm concerned about when we're addressing those in context of this case law is that what we're essentially creating is a default admission for nature of the relationship evidence. And that's not what is intended. What is intended is for the court to independently analyze each piece of evidence and determine the relevance for that particular case. And if the hearsay statement...
The relationship determined to some extent whether it's relevance. When we're talking about relevance, we're talking about permissible inferences that can be drawn from a piece of evidence. Here, her statement. If you have a woman in a domestic relationship who repeatedly states, I'm afraid my son is going to kill me, I'm afraid of him, I think I'm going to die, does that seem like an unreasonable inference to assume that he may be doing something to cause that fear? I mean, that's really the question, right? What is permissible from a particular statement? And in the context of domestic relationships, that doesn't strike me as a completely bizarre or impermissible inference.
Question then becomes, I think, how you present that to the jury if we're going to do that. Again, I make the distinction.
That's right. I mean, inferring that some conduct occurred. I mean, it's not an you're no longer interested in the state of mind. You're interested in what the state of mind might lead you to.
So the district court, I think, can certainly consider in its admissibility analysis the connection to conduct by the defendant, if there is a connection. But when we get to the jury, it's really supposed to be just the statement of fear and not all this extraneous information that may or may not be verified. And again, I think McCormick really talks to this in that, granted, if it's a generalized statement of fear, there's the concern that jurors will speculate. But if the jury is allowed to hear this extraneous information about allegations regarding defendant's conduct, then they're going to use those for an improper purpose. And so what McCormick really says is the way jurisdictions have dealt with it is either they exclude the statement entirely, they parse it, or they provide a limiting instruction.
The statements were made by mom. I wished she had not been murdered, but let's say he almost killed her and didn't quite. And she's going to testify about these things. That's called circumstantial, a lot of the things you're talking about. For example, I think it's in the record, his probation officer, first of all, ding, 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 that's going to go off with the juror. Probation officer, what's he been up to? Been on probation for 7 years. Mom, do you agree with me that her statements would be relevant, that she'd get to testify about those things that the defendant said and what she did?
In court, an ability to testify to anything she observed or heard.
It was relevant, and she's talking about stuff that the defendant said and did, right?
The problem with this here,
So I can go to the next one. Am I right on that? That she would get to testify and those things would be relevant?
would.
Now, because she's dead, we have to think of another way for the prosecution has to get creative and think, how can I get those statements in? Just because she died doesn't make them irrelevant, does it?
Unreliable. She's subject to cross-examination on the stand if she's testifying.
No, that not subject to cross-examination. That's the job of a good defense attorney, too.
About weight versus relevance. The jury can decide weight. The jury doesn't get to decide relevance. The court does.
It's relevant information, whether she's dead or alive.
It would be for the court to determine if it's relevant. I think the court could.
I mean, break this down a little bit. If why wouldn't there? I don't see really a limiting principle. Why couldn't you introduce in any murder case the evidence that the victim was afraid of the defendant, if you can get it in here?
Be relevant to some legitimate issue and dispute, and just generalized fear of a declarant. What's the relevance? Anybody can be afraid of anything.
Always argue that that this shows the defendant had a bad relationship with the victim beforehand, right?
We ask for a new trial. Thank you.
Case of State versus Thompson is hereby submitted, and court is adjourned for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.